Well, good morning, ladies and gentlemen. The time is 10 a.m. Cayman Islands time. Welcome to the meeting of the scheme creditors of Ocean Rig UDW Inc. in provisional liquidation. I'll refer to the company as UDW. My name is Simon Appel. I'm one of the joint provisional liquidators of UDW and a managing director at Alex Partners. Eleanor Fisher of Calo, who's sitting on my left, is the other joint provisional liquidator. I will refer to us as the JPLs. All present should please note that this meeting is being recorded. Some creditors are participating in today's meeting by telephone. In order to ensure the meeting proceeds in an orderly fashion and to ensure everyone has an opportunity to be heard at the appropriate time, we will place all phone lines on mute until the question and answer section of the meeting, at which time those seeking to ask a question will be able to do so through the phone. As set out in the explanatory statement, only those creditors attending physically in person or by proxy will be counted for the purposes of the quorum of the UDW scheme meeting and participate in the vote. The JPL advisors in attendance at this UDW scheme meeting are Rachel Reynolds of Auger, the JPL's Cayman Islands legal advisors, and Patrick Core of Sidley Austin, the JPL's US and English legal advisors. Iraklis Sabronis, the Vice President of Business Development and Company Secretary of UDW, and Company Secretary and Director of each of the three subsidiaries of UDW, Drillships Financing Holdings Inc., Drillships Ocean Ventures Inc., and Drill Rigs Holdings Inc., which I'll refer to as DFH, DOV, and DRH, respectively, is here in person. Michael Pearson, a Class A Director of UDW and a Director of each of DFH, DOV, and DRH, and Anthony Kandelides, the President and Chief Financial Officer of UDW, and President, Treasurer, and Director of each of DFH, DOV, and DRH are in attendance by telephone. UDW's advisors in attendance are Caroline Moran and Nick Herod of Maples and Calder, UDW's Cayman Islands legal advisors, and Scott Morrison of Orrick, Harrington, and Sutcliffe, UDW's US and English legal advisors. Representatives of Prime Clerk as information agent are also joining the meeting. I will take the notice of the UDW scheme meeting as read, although copies of the notice are available if any UDW scheme creditor wishes to read the notice now. Today's UDW scheme meeting has been convened pursuant to an order of the Grand Court of the Cayman Islands dated 20th of July 2017 for the purposes of considering and, if thought fit, approving, with or without modification, a scheme of arrangement under Section 86 of the Companies Law 2016 revision proposed to be made between UDW and the UDW scheme creditors. Under the court order, I have been appointed as chairman of this UDW scheme meeting. The agenda for the meeting will be as follows. First, I will deal with some administrative matters. Secondly, I'll provide some background and an update, including a brief summary of the JPL's role in the restructuring, a high-level overview of the convening hearing, which was held from the 11th to 13th of July 2017, and details of the latest proposal received from Highland Capital Management LP, who acts on behalf of its funds and managed accounts and hold a majority of the 2019 notes issued by UDW and represent 2.04% of UDW scheme claims, and I'll refer to them as Highland. Thirdly, there'll be an opportunity for questions, and fourthly, the UDW scheme creditors will vote on the proposal. The UDW scheme creditors who are entitled to vote at this UDW scheme meeting are the UDW scheme creditors as at the record time on the record date, which was Wednesday. The constitution of the class of UDW scheme creditors is set out in the explanatory statement and the court order. The scheme meetings for DFH, DOV and DRH will follow this meeting. In addition to the proxies I hold as chairman of the UDW scheme meeting, there are a number of proxy holders and/or creditors attending in person. Accordingly, the UDW scheme meeting is quorate. Due notice of the UDW scheme meeting has been given to UDW scheme creditors, and I formally declare the UDW scheme meeting as duly convened. I shall now turn to the first item on the agenda, which is to address some administrative matters. The DFH meeting is scheduled to commence at 10:30 this morning, which is approximately 25 minutes from now. I'm conscious that, given the interest in this meeting, 25 minutes may not be enough time to conclude all matters, and it is critically important to me that proper time is allowed. So, if we find that we need additional time, I propose to adjourn this meeting to allow for the DFH, DOV and DRH meetings to take place, and then reconvene this UDW meeting at what I expect will be around 12:30 p.m. Cayman time. But let's see how we get on. Everyone attending this UDW scheme meeting in person should have registered at the registration desks on entry. UDW scheme creditors attending in person will need to register if they wish to cast their vote today, because they will need to produce to the information agent the required evidence of entitlement to vote. If there's anyone in the room who's not registered for this UDW scheme meeting, please raise your hand now. I can confirm for those on the phone that no one has raised their hand. Under the procedures which have been established to enable UDW scheme creditors to vote on the UDW scheme, each UDW scheme creditor has been given a choice. A, to appoint the chairman as its proxy to vote on the UDW scheme on its behalf at this UDW scheme meeting. B, to appoint a proxy other than the chairman to attend and vote at this UDW scheme meeting on its behalf. Or C, to attend and vote on the UDW scheme at this UDW scheme meeting in person or by a duly authorised representative, if a corporation. The vote on the UDW scheme for those attending in person or by proxy or by authorised representative will be taken by way of a poll. Each UDW scheme creditor attending in person or by proxy or by authorised representative should have received a poll card at registration. If you've not received a poll card, are eligible to vote and wish to vote, please raise your hand now and someone will assist you.
Yep. They were distributed. Yep.
Okay. Well, we'll pick that up at voting and deal with that then. When the formal votes are taken, the poll cards, which will be circulated then, will be collected. They'll then be verified against the duplicate poll cards registered at the registration desk earlier today. The next item on the agenda is some background and an update. Information concerning the proposed UDW scheme, together with a copy of the proposed UDW scheme, is set out in the explanatory statement, which has been made available to all creditors on the information agent website in draft form on the 30th of May 2017 and in final form on the 21st of July 2017. The purpose of the proposed UDW scheme is to implement a restructuring proposal made by UDW to the UDW scheme creditors. The UDW scheme is conditional upon 1, the approval of both the DFH scheme and the DOV scheme at the relevant scheme meetings, 2, the sanction of each of the UDW scheme, the DFH scheme and the DOV scheme by the Cayman Court, and 3, the recognition and enforcement of each of the UDW scheme, the DFH scheme and the DOV scheme by the US Court, unless such requirement is waived in accordance with the UDW scheme. If any of the UDW scheme, the DFH scheme or the DOV scheme is not approved by creditors, sanctioned by the Cayman Court and enforced by the US Court, subject to the waiver by the majority of UDW scheme creditors by value, none of them will be effective. The UDW scheme is not dependent on approval of the DRH scheme, although the DRH scheme is dependent on the UDW scheme becoming effective. I'm not proposing to go through any information contained in the explanatory statement at this stage, as there will be an opportunity for creditors to ask questions about the explanatory statement and the scheme itself later in the meeting. But I do want to provide a few words on the role of the JPLs in the restructuring, an overview of the convening hearing, and provide creditors with details of Highland's latest proposal. Let me start with the JPL's role in the restructuring. The JPLs were appointed by orders of the Cayman Court dated 27th of March 2017 with respect to each of the scheme companies, and pursuant to the terms of those orders, the JPLs were authorised to consider, and if the JPLs thought it appropriate, together with the directors of the scheme companies, to promote the schemes. A summary of some of the steps taken by the JPLs prior to our decision to promote the schemes includes 1, entering into a cash and management protocol with the scheme companies, 2, appointing independent legal counsel in Cayman, the US and the UK, 3, applying for Chapter 15 recognition, 4, undertaking analytical work to understand the business assets and liabilities of the scheme companies, including business plans, valuations, and liquidation and allocation analyses. 5, engaging directly and/or through their advisors with a number of stakeholders in the scheme companies, including an ad hoc group of term lenders, an ad hoc group of DRH note holders, and Highland. 6, considering other scheme proposals from Highland. 7, considering the establishment of a prescribed claims trust to deal with claims alleged by Highland in a draft complaint. And 8, attending regular meetings with the scheme company's management, including telephone call meetings on an almost daily basis. In light of the work carried out by the JPLs, and with the benefit of all of the information provided to the JPLs consider that the terms of the schemes are such that A, scheme creditors are likely to receive a recovery that is greater than that which would be received in a liquidation, and B, the schemes are fair in the sense that an intelligent and honest creditor, acting in respect of his interest, might reasonably vote in favour of them. The JPLs have therefore decided to promote the schemes and requested that the Cayman Court grant orders directing that meetings of the scheme creditors of each of the scheme companies be convened for the purpose of presenting the schemes to the scheme creditors. Let me now turn to the convening hearing. On the 11th to 13th of July, the Cayman Court heard the application for orders for the scheme meetings to be convened. Highland appeared at the convening hearing and objected to the UDW scheme. Broadly speaking, Highland's objections fell into 2 categories. First, Highland challenged UDW's proposed class composition on the UDW scheme and argued that their rights as a 2019 note holder were so different to the rights of the UDW guarantee creditors that they could not properly consult together in respect of the UDW scheme. And secondly, Highland raised issues as to the fairness of the UDW scheme. Highland also argued that the claims which it asserted in the draft complaint, which it lodged as part of its objection to the Chapter 15 recognition application, would be extinguished as a result of the UDW scheme, as Highland would lose its creditor status and would not have standing to bring claims under the New York debtor and creditor law. The Honourable Justice Parker, a judge of the Grand Court of the Cayman Islands, heard arguments over the course of 3 days and then reserved his decision in order to give further consideration to the points raised. On 19 July 2017, Justice Parker delivered a brief decision, with reasons to follow, in which he confirmed that he considered it appropriate to grant the applications of the scheme companies and ordered that the scheme meetings be convened with a single class of creditors in each scheme in accordance with the directions proposed by the companies in their draft orders. For completeness, I should also add that at the conclusion of the convening hearing, Justice Parker heard a separate application by the JPLs in respect of the manner of seeking approval of their remuneration. Justice Parker gave a direction that the JPLs were not required to convene a separate meeting of creditors of the scheme companies solely for the purpose of asking creditors to consider and approve their fees. Accordingly, by voting in favour of the schemes, scheme creditors are also agreeing to the payment of the costs of the restructuring, including the JPL's fees and disbursements, subject to the Cayman Court's approval of the JPL's fees and disbursements following the scheme sanction hearings. And finally, for this part of the agenda, I'd like to touch on the most recent proposal from Highland. On Friday, the 4th of August, just 7 days ago, we received an offer from Collis Krill on behalf of their client, Highland. The Collis Krill letter made it clear that Highland does not want to be party to the UDW scheme, which it considers unfair to it, because under the terms of the UDW scheme, Highland, just like all other UDW scheme creditors, would lose the right to bring its own claims in relation to those issues which are to be investigated by the trustees of the Preserved Claims Trust. Highland's proposal is that Highland be carved out of the UDW scheme in order to preserve its standing as a creditor of UDW for the full amount owed to it under the 2019 notes. That's approximately $74 million. The effect would be that Highland would continue to have the right to pursue all personal claims that it might have against the management of UDW or other third parties through its status as a creditor of UDW. For the avoidance of doubt, the sums due to Highland would remain due and would in no way be extinguished by the UDW scheme. However, in return for that carve-out, Highland would not now or in the future seek to collect from UDW any sums due to Highland under the terms of the 2019 notes or any scheme consideration in respect of that claim. This would effectively relieve UDW of the obligation to provide cash of at least $5.1 million or equity consideration of $7.1 million. The proposal noted, for the avoidance of doubt, that nothing in the UDW scheme should limit or otherwise impair Highland's ability to pursue claims against persons other than UDW that arise out of Highland's status as a 2019 note holder. The offer was made on an in-principle and subject-to-contract basis, albeit Highland believed that the amendments required to the explanatory statement would be minimal. As JPLs, our role is to have regard to the interests of all creditors and to make sure that all creditors are treated fairly. That is why we are keen to ensure that the Preserved Claims Trust should be set up to investigate Highland's complaints for the benefit of all creditors. As we previously stated, the JPLs have not investigated the matters alleged in Highland's draft complaint, so at this stage we have no idea what might be recovered in respect of such claims and are not able to value the opportunity which Highland would like to preserve for itself. But it is notable that Highland considers that such claims to be, and I quote, significantly more valuable than the scheme consideration earmarked for Highland under the UDW scheme. The JPLs had concerns regarding Highland's proposal, including that it would allow Highland to compete with the Preserved Claims Trust in respect of what are essentially the same claims, and that getting the detail of Highland's proposed terms finalised and making the required amendments to the scheme documents would likely be much more complex and take much more time than Highland suggested, which could jeopardise the timetable. However, before taking any final view on the merits of the offer, the JPLs felt it was critically important to try to get some sense of the likely reaction of creditors to Highland's proposal. We therefore contacted the lawyers acting for the ad hoc group of term lenders, Messrs Milbank, Tweed, Hadley and McCloy, for their client's view, as without their support, given they represent 44.78% in value of UDW scheme creditors, the proposal would not receive the requisite support it required. In a response received on the 9th of August 2017, we were formally advised that the ad hoc group of term lenders were not willing to agree to Highland's proposal. As a result of this, the JPLs have concluded, inevitably, that any variation to the UDW scheme to accommodate the Highland proposal is bound to fail, and the proposal is, therefore, simply not achievable. For completeness, I should add that Highland have made it clear that should the scheme be approved by creditors, it is currently their intention to challenge the fairness of the UDW scheme at the sanction hearing. The next item on the agenda is questions. I'd like to give the UDW scheme creditors an opportunity to ask questions. For those in the room who wish to ask a question, I'll ask you to raise your hand. And for those on the telephone, please press *1 and the operator will place you in a queue for your line to be unmuted. Please could anyone asking a question give your name and the name of the UDW scheme creditor which you represent. I also remind you that this meeting is being recorded. So, are there any questions?
I have some questions. I'm Scott Ellington with Highland, representing the Highland Funds. I have questions for the UDW representative. What's your actual position with the UDW, and what do you serve in terms of the community?
I am the Vice President of Business Development for UDW, and I'm also the Secretary for UDW.
And as the Chairman summarized, you're aware of the terms of the scheme, I would assume?
Of course.
And of the proposed preserved litigation rights trust?
Yes.
And you're, again, as he summarized in the August 4th letter, you're familiar with how the Highland parties have asked to not be included in the scheme.
Could you explain that?
That we, on our August 4th communication, made a proposal where the Highland parties would not be part of the scheme as proposed. Are you aware of that correspondence and that request?
We are aware of the proposal, yes.
Okay. And that was rejected, correct?
Correct.
And that rejection, can you explain to me why that was rejected?
Can I perhaps pick this up? So I spoke about the Highland proposal in my introduction. I advised the meeting of Highland's wish to be carved out of the UDW scheme. I provided details of its proposal to give up its right to collect sums due to Highland under the terms of the 2019 note and any scheme consideration. I summarised the JPL's concerns. I informed the meetings of the steps taken by the JPLs to canvass creditors' views on the proposal. I've informed creditors that since the proposal was not supported by the ad hoc group of lenders, it was bound to fail. And I advised the meeting that Highland is seeking to oppose the court sanction of the UDW scheme. UDW's counsel and counsel for the ad hoc group have also responded to Highland detailing their respective concerns regarding its proposal. And apart from reading those responses to the meeting, which I'm happy to do so if you wish, I think that the creditors have sufficient information regarding this issue to allow them to make an informed decision regarding the merits of the scheme, which they've been asked to vote on.
Okay. I appreciate your summary. I'll listen both times intently. I thought this was a process and not a formality, so I'd really like to know what UDW's perspective on the rejection is.
So perhaps, as I said, if it helps, I can read to the meeting the note that UDW's counsel sent to Highland, which outlined some of their concerns. Would that help?
Well, that's counsel's position. I'd actually just like to know from the debtor what their position is on rejection.
Sorry, Simon, it's Anthony. I think the letter reflects the company's position. So if you want to read it, that would be our position.
Thank you. So,
all right, read your letter.
We have it here.
So I am reading a letter from Appleby to Collis Krill. It's dated the... Oh, I'm sorry. I beg your pardon. Here we are. I am reading a letter from Maples to Collis Krill, dated the 9th of August, 2017. The letter says, Dear Sirs, thank you for your letter of 4 August 2017. We adopt the definitions used in our previous correspondence unless otherwise specified. For the reasons set out below, your proposal is not acceptable to our client. In light of the ad hoc group's position that they do not support Highland's proposal, any amendment to the UDW scheme on those terms would be bound to be rejected. In any event, it is our client's position that the UDW scheme treats all UDW scheme creditors fairly and reasonably in accordance with their rights against UDW and their interests as members of the class of the UDW scheme creditors. This position is reflected in the overwhelming creditor support for the UDW scheme. Our client's position remains that Highland is not entitled to different treatment from other members of the class of UDW scheme creditors. This is despite Highland's repeated efforts to engineer a return greater than that available to other UDW scheme creditors. It is not the case that the purpose of the UDW scheme is to shield any party from investigation as alleged in your letter. Our client accepts that the allegations in the draft complaint should be investigated regardless of their merits and notwithstanding the fact that Highland has not filed a complaint in New York or elsewhere. Therefore, UDW has proposed the creation of the Preserved Claims Trust, the PCT, as part of the UDW scheme. The PCT ensures that UDW scheme creditors be given fair and equal treatment in respect of the possible prosecution of claims arising out of the circumstances identified in the draft complaint. This work is to be undertaken by an independent fiduciary. Further, under the terms of the PCT, any recoveries that may be realized from the prosecution of such claims would be shared ratably amongst all UDW scheme creditors, and not just Highland or the 2019 note holders. Moreover, we disagree with your assertion that the amendments to the UDW scheme required to give effect to your proposal would be simple or inexpensive. To maintain the existence of a debt, but to remove all rights of recourse against UDW and members of the group in respect of that debt in a way satisfactory to the restructured group, its creditors and investors would involve considerable complexity. This makes it very difficult for UDW to accede to your proposal. Finally, given that your client's proposal was made less than 5 business days before the scheme meeting and 2 business days before the record date, such an amendment would, in any event, now be administratively unworkable and at a minimum cause delay in approving the schemes. This is likely to have knock-on consequences for the implementation of the restructuring, including affecting the NASDAQ listing, the continuation of existing drilling contracts, and increasing the restructuring costs. In this regard, we note that your client has been in possession of the explanatory statement and the terms of the UDW scheme for over 2 months.
Thank you, I appreciate that. I would like the record to reflect that we find this objectively unfair, that the PCT may not serve the fiduciary duty that we, Highland, have to our investors, especially our 40 Act mutual fund investors, under the Registered Investment Advisors Act and the SEC regs, that this is fair to all creditors. Anyone who would like to join in our efforts can, and this is no detriment to the estate. We're foregoing the cash compensation from the estate to continue to pursue rights and remedies that we're in our fiduciary duty to pursue, and therefore it's objectively unfair for those rights and remedies to be impinged upon and or limited.
Thank you. Those notes, that has been noted. Now, I'm just conscious of the time. It is now 10:30, which is the time at which the next meeting has been scheduled. So I propose to adjourn this meeting now. We'll deal with the other three meetings, and then we'll reconvene in 2 hours at 12:30.
Can I also ask, in the next meeting, could you come up to the front? We're having difficulty picking you up on the...
That's fine.
Okay. Great. Thank you. Operator, we're now adjourning this meeting, and we'll have a break before we start the next meeting in a few minutes' time. Thank you.
And we will be transferring everyone to the next meeting.
Thank you. And can you only get those attendees entering the meeting when I tell you?
Yes.
Thank you.
Okay. Thank you.
And ladies and gentlemen, this is the operator. This conference is now concluded. You may now disconnect and dial back in for your future conferences.
Well, good afternoon, ladies and gentlemen. Welcome back to the reconvened meeting of scheme creditors of UDW. Just before we go back to where we left, just for the record, earlier today I mentioned that the record date was Wednesday. It was in fact Thursday, so that will just be corrected for the record. So when we left off, we were considering any questions creditors had. So let's pick up from there. I'll remind people that this meeting is being recorded. For those on the telephone, please press *1 if you wish to ask a question, and for anybody in the room, please raise your hand. So are there any additional questions? No, I can confirm there are no additional questions. So moving on to the final item of the agenda, which is the voting. UDW scheme creditors present either in person or by authorised representative should be aware that they are entitled to vote, but to do so will render invalid any proxy previously given by them. As set out in the explanatory statement, a scheme of arrangement will become legally binding on all holders of claims subject to the scheme, including both those voting against the scheme of arrangement and those not voting, if at least a majority in number of the relevant creditors holding at least 75% in value of claims present and voting either in person or by proxy at the scheme meeting vote in favour of the scheme of arrangement and the Cayman Court then sanctions it. I will now put to this UDW scheme meeting the formal resolution on which UDW scheme creditors are to vote, which is that the scheme of arrangement, a copy of which has been tabled at this scheme meeting, be approved subject to any modification, addition or condition which the Grand Court of the Cayman Islands may think fit to approve or impose, which would not directly or indirectly have a material adverse effect on the rights of the scheme creditors. I have here a copy of the UDW scheme, which I will initial for the purposes of identification. As chairman of this meeting, I have instructions by proxy from 264 UDW scheme creditors, accounting for an aggregate value of approximately $1.9 billion. I will be completing a poll card accordingly. Please would all scheme creditors or their proxies who wish to vote in relation to the UDW scheme complete the poll card in accordance with the instructions on it and sign it. If you do need any help, please raise your hand. We will just take a few minutes to review and count the poll cards before I announce the outcome of the vote and conclude the meeting. So, having reviewed and counted the poll cards, I can confirm that 97.92% by value and 98.53% by number of UDW scheme creditors present and voting at this meeting, either in person or by proxy, have approved the UDW scheme. For the record, 2.08% in value and 1.47% in number voted against the resolution. The requisite approval of the UDW scheme creditors to the UDW scheme has therefore been obtained. That concludes the formal business of the meeting. In terms of next steps, subject to the scheme creditors of the DFH scheme and DOV scheme voting in favour of the respective schemes, the court hearing to sanction the UDW, DFH and DOV schemes will be held on the 4th, 5th and 6th of September 2017 at 10 a.m. Cayman Islands time. Scheme creditors are entitled to appear and make representations at that hearing, although they are not obliged to do so. If any scheme creditor wishes to appear at this hearing, they should give notice that they intend to do so to the JPLs as soon as possible. Assuming all the conditions for the UDW scheme are met, the order of the Grand Court approving the UDW scheme will be delivered by the JPLs to the Cayman Islands Registrar of Companies for registration, and the UDW restructuring documents will be executed. However, the effective date of the UDW scheme will occur on the restructuring effective date, provided that this occurs before the 31st of October 2017, subject to that date being extended in accordance with the terms of the UDW scheme. The restructuring effective date will be announced by notice published through the Information Agent website, as well as by press release on the group's website. Thank you all very much for coming today. I declare this UDW scheme meeting closed at 12:39. Thank you. Operator, that concludes the call. Thank you.
Thank you so much.